It is my great pleasure and honor to welcome you to this virtual side event to the 46th session of the Human Rights Council. Today's discussion will be devoted to the human rights responsibilities of armed non-state actors and will mostly discuss the joint statement that was recently released by special procedure mandate holders of the United Nations. And today's discussion is co-organized by the Federal Department of Foreign Affairs of Switzerland, the branch of special procedures of the Office of the High Commissioner of Human Rights, the Geneva Academy, as well as the Geneva Human Rights Platform. Before giving the floor to our distinguished speakers today, I just want to say a few words on the runouts of the discussion as well as on housekeeping. So starting with housekeeping, you will have noticed that you all have access to your cameras and microphones. I ask you to please be on mute when you're not speaking and feel free to have your cameras on if you want to, and please do turn them on if you're speaking. You will be able to interact with our panelists during the second half of today's discussion. So if you wish to take the floor, ask a question or make a comment, please either write in the chat feature or use the raise your hand button, and I will give you the floor on a first come, first served basis. And in terms of how today's discussion is going to go, we're first going to have about 10 minutes of introductory remarks. Then we're going to turn to the panel discussion itself, which is going to last about 35 minutes. And then we are going to have an interactive segment. First, we'll give the floor to mandate holders who have signed the joint statement, but who are not on the panel today. We have video recordings, and if some of you are also in the virtual room with us, please don't hesitate to ask for the floor. And then we should have about 30 minutes for Q&A. So before further ado, I'm going to briefly introduce each of our speakers. So giving introductory remarks today, we have Professor Gloria Gaggioli, who is the director of the Geneva Academy of International Humanitarian Law and Human Rights. We also have Ambassador Corinne Ciceron-Buller, who is the head of the Directorate of International Law at the Swiss Department of Foreign Affairs. And then, as part of our panel, we have Special Rapporteur Nils Melzer, who, as many of you know or should know, is the Special Rapporteur on torture, other cruel, inhuman, or degraded treatment. We have Mrs. Agnès Callamard, who is the Special Rapporteur on extrajudicial summary or arbitrary executions. Ms. Jelena Aparac, the chair of the working group on the use of mercenaries as a mean of violating human rights and impeding the exercise of the rights of people to self-determination. And then last but not least, we have Mr. Gehad Mahdi, who is the vice chairperson of the Committee on the Rights of the Child. So I look forward to today's discussion, and without further ado, Professor Gaggioli, you have the floor for your introduction.
Thank you very much, Emily. So Excellencies, dear panelists, ladies and gentlemen, it is a pleasure for me to be with you for this side event to the 46th session of the Human Rights Council on the human rights responsibilities of armed non-state actors. It is also an honor for the Geneva Academy to co-organize through the Geneva Human Rights Platform this side event alongside the OHCHR and the branch of special procedures and the Federal Department of Foreign Affairs of Switzerland. The mission of the Geneva Human Rights Platform consists in providing a neutral and dynamic forum of interaction between United Nations human rights experts on topical issues. And that is exactly the purpose of today's event. Our objective is to focus on the joint statement on human rights responsibilities of armed non-state actors that was issued last week by 44 independent experts representing 28 special procedures of the Human Rights Council. Such a large number of signatories and the diversity of mandates they represent testifies not only to the importance of the issue, but also to the far-reaching negative impact on the human rights of individuals and groups that result from armed non-state actors' behaviors. For 10 years now, the Geneva Academy has dealt with legal and policy issues stemming from the involvement of armed non-state actors in armed conflicts and other situations of violence. Unfortunately, these issues remain extremely vivid today and have a worldwide impact on notably the life, security, and dignity of individuals on a daily basis. Since 2017, and thanks to the essential support provided by the FDFA, the Geneva Academy has facilitated, supported, and accompanied the work of interested United Nations human rights experts, and chiefly Professor Agnès Calamard and Professor Niels Meltzer, who is also our human rights chair at the Geneva Academy. These efforts resulted in the joint statement, which constitutes a timely and much needed endeavor, given the absence of an institutional position of the OHCHR on human rights responsibilities of armed non-state actors. The joint statement highlights challenges resulting from the ongoing debate about the extent and content of human rights responsibilities of armed non-state actors. So in an effort to really move away from a strictly legal reasoning and thus to acknowledge the practical consequences of existing violations from a victim's perspective, it also addresses important recommendations to states, armed non-state actors, and other stakeholders such as the United Nations. I look forward to our discussions and to continuing engagement on those issues with United Nations human rights experts. Please let me now give the floor to Ambassador Corinne Ciceron-Buller, the Director of the Directorate of International Law at the FDFA, for the opening statement. Thank you.
Thank you, Gloria. Excellencies, dear panelists, ladies and gentlemen, also on behalf of the Federal Department of Foreign Affairs of Switzerland, I warmly welcome you to this virtual panel discussion on human rights responsibilities of armed non-state actors. Today, a large majority of conflicts are non-international in nature. While armed non-state actors are doubtlessly bound by international humanitarian law, the situation is far less clear for the respect and protection of human rights by such actors. But victims must be in a position to seek redress for violation of abuses of their human rights, regardless of the actor at the origin of their grievance. Switzerland, together with the Academy, has identified this gap in human rights protection and is sensitive to its concrete effects on the ground. Let me echo what Ms. Gajoli has just pointed out. The fact that no less than 44 UN human rights experts have explored this issue demonstrates the relevance of discussing human rights responsibilities of armed non-state actors. Ladies and gentlemen, the protection of civilians in armed conflicts and the call for greater accountability are at the core of the Swiss foreign policy priorities. We support an effective international criminal court as well as efficient mechanisms contributing to holding perpetrators of atrocity crimes to account. But this important engagement after massive human rights violations and other crimes have been committed has to be complemented with a robust prevention agenda aiming to reach one goal: to protect all individuals from infringement of their dignity and to prevent violation and abuses of their human rights and fundamental freedoms. In order to reach this goal, it is first and foremost up to states to meet their human rights obligation throughout their territory. However, we must address the gap in human rights protection if states are unwilling or unable to guarantee human rights on their territory and where armed non-state actors are exercising either government-like functions or de facto control over territory and population. Ladies and gentlemen, we believe it is important to discuss the human rights responsibility of armed non-state actors more precisely. At the same time, it is clear that none of the findings regarding the legal nature of these responsibilities should ever minimize or question the primary responsibility of states for the respect and protection of human rights. In their joint statement, the UN human rights experts have taken this into account and addressed also states. It will be very interesting to hear different perspectives on how their recommendations can be put into practice. I look forward to hear more about the experience of the panelists with regard to their areas of activity and wish all of us a very interesting event. Thanks for your attention.
Thank you so much, Professor Gadjoli and Ambassador Ciceron-Buller. I think those are great introduction to the challenges and the main salient features of today's discussion. So without further ado, I invite us to turn to the panel discussion itself. And we'll start first with Agnès Calamar's presentation.
Thank you very much. Thank you to the Geneva Academy and the Swiss government and the OHCHR for organizing this side event. In 2009, then UN Secretary General Ban Ki-moon observed that, and I quote, "We need urgently to develop a comprehensive approach towards improving compliance by all these non-state armed groups with the law, encompassing actions that range from engagement to enforcement." It is my view as a UN Special Rapporteur on extrajudicial summary or arbitrary executions that armed non-state actors can be accommodated as subject of international human rights law without treating them as akin to state. That armed non-state actors are not bound by the full range of human rights law guarantees, but to a threshold of norms derived from their capacity that I have defined as a mixture of control and governance. And before elaborating further, let me insist on one additional point. Attributing certain human rights obligations to armed non-state actors is not meant to validate their authority. It is not meant to acknowledge or increase their legitimacy at the international level. It is not meant to replace or duplicate state responsibility. It is meant to support and complement those responsibilities, and it is first and foremost meant to protect people and potential victims. So my position that armed groups have human rights obligations is predicated on three main foundations. First, as we all know, and as has been reiterated in the introduction, they have been responsible for countless human rights violations, violations of international humanitarian law, crimes against humanity, and genocide. They exert significant influence over the lives and well-beings of millions of people around the world. Second, over the last 10, 15 years, there have been concerted efforts to strengthen the international protection of civilians against violation by armed non-state actors. Member states, through the UN Security Council, the General Assembly, or indeed the Human Rights Council, have regularly addressed armed groups, both as perpetrators of human rights violations and as duty bearers. Under the terms of this resolution, international obligations applicable to armed groups are derived from international human rights, humanitarian, refugee, and criminal law. Indeed, the obligations of armed groups may include the obligation to respect use current norms, customary human rights, and humanitarian law, or they may even be broader. A third rationale for binding armed groups to human rights obligation is that the current legal framework to hold them accountable has an unacceptably large deficit for the victims with regard to access to justice, remedies, and reparation. And indeed, this is a focus of the joint statement that we have produced last month. For instance, there are many situations where the state obligation to protect is not enough or cannot apply, such as in the context of non-international armed conflict or whenever armed non-state actors have escaped the effective control of the state. Second, limiting their accountability to international humanitarian law, as is often argued, is resulting in an inequality of obligations between them and state parties to a conflict, which remain bound by international human rights law. Thirdly, there are situations involving armed non-state actors and massive loss of lives, which are not armed conflict, and therefore where IHL does not apply. For instance, so-called low-intensity conflict involving organized criminal cartel groups. And I finally wish to remind us all that international criminal law does not provide for reparations to victims of violations committed by armed non-state actors, while states that have domesticated the Rome Statute do not necessarily undertake to establish just judicial remedies for individual reparation. Anyway, there are many gaps, many vacuums, which mandate that we, as human rights experts, as a human rights community, be prepared to challenge our doctrine and to support the right of victims for justice and reparation. So in view of those gaps, I am suggesting that the 4 bodies of law that are currently applied to armed groups are not sufficient, do not work enough to provide remedies, justice, and should be complemented by international human rights law. I further suggest that the application of human rights obligation to armed groups should occur in a context-dependent, armed group specific, and gradated manner. The central element of my position is that the content and extent of the human rights obligation of armed groups or armed non-state actors are determined through a review of 3 interlinked indicators. 1, the nature and extent of their control in the traditional sense of the word. 2, the level of their governance functions. And 3, and consequently, the extent of their capacity under international law. In my view, and as applied to the right to life, my analysis has led me to suggest that there are some basic obligations or principles that should apply to all armed groups, independently of the context. The first one is a principle of non-discrimination. Central to human rights, it applies with particular force to the right to life. The second is the obligation to respect the right to life. That is primarily a negative obligation, which require that armed groups do not violate the individual's right to life, i.e. do not engage in arbitrary deprivation of life. And in my view, that prohibition applies to all NSAs in all situations. There are questions regarding law enforcement situation. If and when performed by our group, that raises many concerns. And here I think we enter into the domain where we need to be very case specific and gradual in our approach to the law enforcement functions of armed groups. But I wish to remind us all that suggesting that these do not apply to them is just placing the population under the control of NSAs without any protection and remedies, because there are a vast amount of armed groups around the world that exercise law enforcement activities. In fact, it is often one of the first activities that armed groups are going to engage in when they take control over a territory. Finally, I will suggest that armed groups, armed non-state actors, may have an obligation to fulfill human rights, including the right to life. In my view, these are not part of a 3rd generation of rights of any kind, of obligations. In fact, they have a particular range of obligations under IHL, which should be extrapolated into human rights law related to minimum survival requirement, health, housing, water, and food. At the very least, at the minimum, all armed non-state actors should be prohibited from withholding access to international assistance to the populations under their control, and they should take all reasonable steps to protect and ensure access to humanitarian aid and other services, particularly to all groups and without discrimination. Let me conclude by pointing out that over the last decades, government, UN agencies, civil societies have engaged with armed non-state actors to ensure respect for human rights and humanitarian standards. There is some very useful work underway. There are initiatives aimed at addressing existing concern and shortcoming and at strengthening our capacity to engage with them. Our joint statement that was released last month encouraged strengthening all of the effort. And it particularly calls on states to contribute and support the clarification and codification of human rights responsibilities of armed non-state actors. Our joint statement calls on states to evaluate current mechanisms for holding armed non-state actors accountable and identify approach to effectively address the current shortcoming and strengthen protection while addressing justice gaps and vacuums. It calls on states to encourage the adoption by armed non-state actors of policies, practice, and codes of conduct for human rights protection. And it does call on states to approach all of those recommendations from a gender-sensitive approach to ensure that those recommendations are implemented, taking into account the heightened risk of abuse against women and girls, and also of other vulnerable groups. I will stop here. Thank you very much for giving me the opportunity to contribute to this panel event and to this important conversation, which has been quite at the heart of the way I have implemented my mandate for the last 5 years.
Thank you very much, Agnès, for this very detailed presentation and for reiterating the fact that from a victim perspective, it's important that this conversation happen, for also detailing your own position on the issue, and finally for highlighting the recommendation to states that are crucially made in the joint statement. And also thank you for all the work you've been doing on this issue throughout your mandate, which is coming to an end. It's been an honor to have you, to engage with you during all this time. Now, without further ado, Special Rapporteur Meltzer, you have the floor.
Thank you very much. Is the sound okay? Can you hear me?
Yes, perfectly.
Okay, wonderful. Thank you. Well, thank you very much to you, Emily, and the Geneva Academy, obviously, and also the government of Switzerland for the support, and all our colleagues without whom and their incessant work on these topics in practice, much of which is invisible, without which we would never have come to this conclusion. And clearly this is not the end of the road, but it is unfortunately only the beginning of a road that will hopefully help improve some of these issues. Many of the things I was going to say have been mentioned by Agnès, who obviously has also been a bit of a trailblazer, at least in my generation of special rapporteurs, because of her thematic report on non-state actors and the right to life. So I'd like to focus really on the prohibition of torture and ill treatment here, and to say, well, make a few remarks on, well, the normative relevance of the prohibition of torture. It is a bit special because of the way it is formulated and defined in the Convention Against Torture, that already encapsulates basically the possibility of non-state actors actually committing torture. If you look precisely at the definition, I will not discuss all elements, obviously, but torture essentially being intentional and purposeful infliction of severe pain or suffering, and other cruel, inhuman, or degrading treatment being other pain or suffering or humiliation that is being inflicted without a legal purpose or a necessity or a proportionality. But in both cases, the convention requires the involvement of a state agent in order for the human rights treaty basically to engender these obligations. But the involvement is perpetration of by a state agent is one option, but then there are three options where it says the instigation by a state official, or the consent by a state official, or the acquiescence even of a state official with an act of torture or ill treatment is sufficient to trigger all these obligations. And clearly, if the state agent were perpetrating it, we would not need to speak of instigation, consent, and acquiescence. So in all these three cases, it's a non-state actor who's actually perpetrating the act. And just because the state agent is consenting, instigating, or acquiescing, it becomes relevant under this particular treaty. And so the convention actually goes very far in clarifying that torture and ill treatment really is something that is not limited to state actors. And so it shows us in the treaty text how practically relevant this actually is. So torture and ill treatment really can be in practice and is unfortunately being perpetrated very often by non-state actors, especially by armed non-state actors, organized armed groups, organized criminals also, private military and security companies and their employees, obviously. But even by corporate actors, other corporate actors, and we could even go down the line to the private sphere of domestic violence and so on. So non-state actors and torture and ill treatment really is not a contradiction, but unfortunately it is very, very common that it is being perpetrated by non-state actors. And so what we're lacking is not the substantive human rights norms, but what we are lacking are, as Agnes had also said, the institutional and a framework, a conceptual framework to actually ensure the enforcement with regard to non-state actors. We have the international criminal law, but it is, as Agnes also indicated, it is limited in its scope. What we are lacking is the equivalent of the legal entity of the state on the non-state actor side. Who is responsible if a group of non-state actors commits human rights violations, apart from the individual? If you can't criminally prosecute them for whatever reason, what's the entity that actually, if it's not a corporate actor where we have a legal entity, what's the legal entity and how do we determine that? And here, so we have this problem all over, even in humanitarian law, where we have clear treaty-based legal obligations of non-state actors to respect humanitarian law. Well, what happens if there are, and unfortunately there are obviously a lot of violations in terms of the civil obligations, the civil law obligations, the compensations, the reparations and all of this? We always have to tie it to persons because it's very difficult to find a legal entity. But the practical relevance is enormous. And since even before I had this mandate, when I worked for the International Committee to Red Cross, I started out in the Kosovo War at the time. Just after the war, the Kosovo Liberation Army, obviously Kosovo was not yet recognized as a state. They had a lot of power and had a lot of influence on the local population, controlled part of the territory, and so we have to deal with that also in a post-war context. The FARC in Colombia, the Taliban in Afghanistan, even the favelas in Brazil that I visited, where criminal groups are controlling the territory really, and the local police can only come in with tanks to exercise their authority. So the human rights dialogue was very, very important in these contexts. And finally, in this mandate, I have to do with these factors all the time. So in terms of individual communications, we have submitted during my tenure 27 joint communications to non-state actors, ranging from armed groups to businesses, private security companies, companies that manage prisons or especially migration centers in the US, for example, very often where this is being outsourced. Extremely important. Now, we would perhaps not always speak of armed non-state actors in this respect, but the whole aspect of non-state actor violence and violations of human rights is of paramount importance. In terms of country visits, I had a very direct involvement with non-state actors in the eastern Ukraine, in the regions of Donetsk and Luhansk, the so-called the self-declared republics of Donetsk and Luhansk, which are basically armed groups and dissident armed forces controlling those territories. And I managed to get partial access to some of their detention places as well. And in my report 2018 to the Human Rights Council about this visit, I also reported on those contacts and how clearly there has been ill treatment and, or at least allegations of ill treatment and torture by those dissident armed forces and also the prison personnel in those prisons. And so it was very important for us to practically be able to engage. And one point, a last point here I would like to make, because it's what's the important advantage of special procedure experts versus treaty bodies in engaging with those non-state actors is that those non-state actors, as in Donetsk and Luhansk, that have ambitions that as FARC would have had before in Colombia to basically achieve independence or some kind of an autonomous government or something like this. They say, well, to the treaty bodies, they will say, you are not authorized to visit in this territory because we are, we're striving for independence and we have not ratified the treaty. While the special procedure mandate holders have a generic mandate that is not tied to treaty parties, state parties to a treaty. So non-state actors are much more prepared to engage with us, while with the treaty bodies, they require that they are allowed to first ratify the treaty, which will obviously then would give them some form of legitimacy, which we are not required to give as special procedure mandate holders. And that was also why the subcommittee on the prevention of torture, which is a treaty body, was not allowed to visit the non-state actor prisons in Eastern Ukraine, while I, as the special rapporteur on torture, I was able to negotiate that access, even though it was not a satisfactory access, but it was at least a first visit that could be achieved that way. I think I'll wrap up here as well, and I'd be happy to respond to any questions anyone else would have. Thank you very much.
Thank you so much, Special Rapporteur Meltzer, for this presentation, for highlighting very concrete example of engagements, and also for highlighting why special procedures are sometimes best placed or do not have the same constraints as treaty bodies or other human rights mechanisms, and also why it's important and why you have been able to achieve this joint statement. So now I would like to give the floor to Jelena Aparach for her presentation.
Thank you, Emily. Can you hear me properly?
Yes.
Okay. So, ladies and gentlemen, and dear colleagues, on behalf of the Working Group on the Use of Mercenaries, I would like to thank the Geneva Academy and Geneva Human Rights Platform for coordinating and supporting the process that led to the joint statement of independent experts on the issue of non-state actors and human rights. I would also like to thank and greet all the panelists and everybody who joined us all over the world for this very important topic today. First, let me start by saying that the Working Group has the explicit mandate to monitor and study the effects of mercenaries, mercenary-related activities, and private military and security companies that I will call PMCs on the enjoyment of human rights. In its mandate resolution 42/9, the Human Rights Council recognized, and I quote, that the mercenary activity is a complex crime in which criminal responsibility falls upon those who have recruited, employed, trained, and financed the mercenary, and upon those who have planned and ordered their criminal activity. In paragraph 6 of the same resolution, the Council, and I quote again, encourages states that import the consultancy security services provided by private companies, including in the extractive industries, to establish national regulatory framework for accountability of the companies and their personnel, and for remedies for violations resulting from their activities in order to ensure their imported services provided by those private companies neither impede the enjoyment of human rights nor violate human rights in their recipient country. The Working Group is also mandated to actively participate in other subsidiary bodies on the Human Rights Council, considering issues related to the use of mercenaries in all their forms and manifestations, including PMCs. For instance, in 2017, the Human Rights Council established the open-ended intergovernmental working group to elaborate the content of an international regulatory framework of the activities of PMCs. the working group has continued to actively pursue the implementation of its mandate and its normative advocacy work to both prevent and ensure accountability for human rights violations committed by PMC's personnel through this intergovernmental working group and its predecessor. Secondly, the Working Group on Mercenaries submit thematic reports to the Human Rights Council and the General Assembly in regards to PMCs and human rights. The necessity to further contribute to and advance the international debate on the legal and normative development of private security has consistently been priority of the Working Group. In its report on phenomenon of foreign fighters and the possible linkages with the mercenarism, the Working Group noted, and I quote again, "As is the case with all other members of state armed forces and non-state armed groups, foreign fighters are, at minimum, bound by the peremptory norms of international law. When committed as part of the widespread or systematic attack directed against any civilian population with knowledge of that attack, these acts constitute a crime against humanity. In addition, non-state armed groups that exercise effective control over territory, such as ISIL, are increasingly considered to be bound by international human rights obligations in relations to all people within their territory." End quote. In 2017, in the case of increasing use of privatized detention, the Working Group stated that, and I quote again, "Although the state ultimately has the obligation to respect, protect, and promote the realization of human rights, there has also been a growing support and acceptance by international community of the principle that the non-state actors, including business entities, must respect international human rights standards and obligations. The responsibility of corporations to respect human rights in their operations and business relationship is now widely accepted concept." End quote. When it comes to corporate actors, the Working Group has studied a specific relationship between two categories of corporation, extractive industry and PMCs, and their impact on human rights. And the Working Group has recognized that a private military or a security company and its personnel providing services to an extractive company in a situation of an armed conflict is bound by the rules set out under international humanitarian law and should respect human rights. Most recently, in the report addressing the role of PMCs in migration and border management, the Working Group noted, quote again, "The international human rights framework sets out clear obligations for states to respect, protect, and fulfill the human rights of all people, including migrants under their jurisdiction, and responsibilities for companies to respect these rights." The mandate holder further noted that, and I quote again, "Given the heightened risk of gross human rights abuses associated with the provision of private military and security services in migration and border management, companies in this sector should pay particular attention to human rights risks and that the business activities or business relationships they may pose, particularly to individual or groups in vulnerable situations." In addition, the Working Group has consistently called on companies to exercise heightened human rights due diligence and has urged companies to be more transparent by publicly disclosing accessible, clear, and non-ambiguous information with regards to their contracts, operations, as well as adverse human rights impacts by their operations. Thirdly, the Working Group can address the corporate human rights responsibility through the process of communications. Any individual, community, or a group with information on alleged human rights abuses by PMCs could submit information to the Working Group. It is one of the most important tools to address corporate human rights responsibility and the only one at the international level today. Unfortunately, the procedure is insufficiently known to a wider audience, and we believe that civil society groups should find ways to use it more extensively. We have also received and taken actions on specific allegations of violations of international humanitarian law and abuses of international human rights law arising from activities of PMCs with concerned governments and companies themselves, as Nils also mentioned. For instance, in the case of migrant detention in Nauru, in the USA, or just recently in Serbia, these communications were sent to all concerned states and to private security companies. In these communications, we reiterate private companies' obligations to respect human rights and embed their respect in their daily operations. their commitment to respect human rights takes many forms, including human rights training of security personnel, refusing disproportionate use of force, following non-discrimination policies, etc. Finally, the working group conducts official country visits to collect first-hand information on the ground, in particular on issues of PMCs and their potential responsibility for human rights abuses. I would like to conclude my statement with observations on two issues. First, throughout reports, it becomes apparent that companies have the responsibility and obligations to respect human rights, in particular when exercising inherent state functions. And second observation is on the interconnectivity between companies, such as extractive companies and private military and security companies, or between companies and states, and there increase the risk of impunity in the absence of transparent and public contractual relationship. On behalf of all members of the working group, I thank you for joining us today, and I look forward, excuse me, and I look forward to hearing the observations and insights of other panelists, and I greatly welcome any future discussion regarding the work of the working group on mercenaries. Thank you.
Thank you so much for this very, very detailed, but also very detailed, summary and explanation about the very varied and evolving engagement of the working group on this issue. It was very enlightening, especially for those of us who are not so familiar with the work of the working group. So last but not least, I would like to give the floor to Mr. Mahdi, representing the Committee on the Rights of the Child. Mr. Mahdi, you have the floor.
Thank you, Emily. Do you hear me? Great. I would like to express my thanks and appreciation to the organizers for inviting me to participate in this very important and timely discussion. Well, the title of my intervention is the engagement of the CRC with ANSA on children's rights in conflict. Well, the term engagement is a bit misleading for us in the CRC, because we are only addressing states according to the convention and according to our mandate. The CRC is handling children's rights in conflict under the optional protocol on the involvement of children in armed conflict. Article 4 of the optional protocol states armed groups that are distinct from armed forces of a state should not, under any circumstances, recruit or use in hostilities persons under the age of 18. Because, you know, our main concern is only children under 18. Paragraph 2 of this article says that states parties shall take all feasible measures to prevent such recruitment and use, including the adoption of legal measures necessary to prohibit and criminalize such practice. In our dialogue with state parties to the optional protocol, we note that considerable number of them do not criminalize in their domestic laws the recruitment of non-state armed groups of children under 18 years of age. Some states party are under the impression that there is no need for them to do that because they don't have non-state armed groups on their territories. But we stress the importance of criminalizing such recruitment, as stated in Article 4, to prevent impunity in case a recruiter or a violator of human rights is found in their territories. Also, in fighting impunity, we call on a state party to exercise extraterritorial jurisdiction over crimes under the optional protocol. Some states which exercise extraterritorial jurisdiction make it conditional to double criminality. And we recommend to them to remove the double criminality including for the purpose of extradition. Article 6, subparagraph 3 states that states parties shall take all feasible measures to ensure that person within their jurisdiction recruited or used in hostilities contrary to the present optional protocol are demobilized or otherwise released from service. States parties shall, when necessary, accord to such persons all appropriate assistance for their physical and psychological recovery and their social reintegration. We emphasize to state party not to criminalize children released from non-state armed groups and consider them as victims rather than criminals, and assist them to be reunited with their families and provide them with all necessary facilities, including healthcare, education, vocational training, for their reintegration into society and prevent their re-recruitment with non-state armed groups. We also recommend to state to establish a mechanism for early detection or identification of migrant or refugees entering their borders who may have been involved in armed conflict abroad, and train border control personnel for that purpose in order to refer them to the appropriate institutions for their psychological and physical assistance and their reintegration into society. Those children are really victims of all human rights principles, and they need to be protected and assisted for their reintegration. Another serious issue emerged in the last few years. That is the abandonment of European children whose parents joined ISIS in Syria and Iraq. Most of them are born there in Syria and Iraq and are detained, waiting for repatriated to their own countries. Some European countries have repatriated few of them, but hundreds still abandoned. We have received some complaints under the third optional protocol on communication procedures, and we are in the process of considering these cases. States are fully responsible for protecting their children, particularly those who are engaged in ISIS and continued to be under the influence of terrorist groups. Thank you very much. I'll stop here and I'll be ready for any question.
Thank you so much, Mr. Mahdi, for recalling that the committee's competence is to engage, interact, give recommendations to states, and also for highlighting, or by this way highlighting, that the joint statement, any initiative or discussion on human rights responsibility of armed non-state actors is also mutually reinforcing of any state's obligation, and the joint statement also addresses a lot of recommendations to states, primarily to start engaging on this issue. So I suggest that we now open the interactive segment of the discussion. We'll hear from two experts who have also signed the joint statement but cannot be with us today. Then we'll open the floor for questions. And then, if that is all right with everyone, I suggest that we keep between 5 and 8 minutes at the end if our panelists want to give concluding remarks and reflect on the way forward. So without further ado, I think we're going to hear first from the special rapporteur on internally displaced persons, who has a video message for us.
Thank you for giving me the floor. As the statement says, non-state armed groups exercising either governmental-like functions or de facto control over territory and populations must respect and protect the human rights of individuals and groups. In my engagements with internally displaced persons in many countries, it is clear that while states do have the primary obligation or responsibility to implement IDP protection, including in the prevention of human rights violations by non-state armed groups in that state concerned, it is equally clear that non-state armed groups have to implement their human rights responsibilities by ensuring that those IDPs in their specific territories are accorded their human rights. Thus, the clear application of the territorial principle. The human rights of internally displaced persons are summarized in the guiding principles on internal displacement, which range from prevention of arbitrary displacement, protection of IDP rights during displacement, and even in ensuring the facilitation of conditions for their durable solutions, which consist of human rights-based criteria. These human rights apply to all internally displaced persons under the control of that non-state armed group. One of the questions raised in this regard is related to whether or not in internal displacement situations caused by armed conflict, for example, the equality of belligerents should be an important principle to take into consideration in the guarantee of the human rights of internally displaced persons and peoples under their control. Or, similar to ongoing discussions in international humanitarian law, should there be a sliding scale of obligations? Definitely, I look forward to the discussions that will hopefully propel action towards more discourse, monitoring, and accountability on this topic. Thank you.
Thank you, Yasmin. And now we have a second message from a representative of the Working Group on Business and Human Rights, Mrs. Anita Ramastrasi. I hope I'm saying this right.
Greetings, I'm Anita Ramasastry, a member of the UN Working Group on Business and Human Rights. I'm sorry I can't be with you live at the Geneva Academy event, but I want to congratulate the two mandates that led on this statement regarding human rights and the obligation of armed non-state actors. The Working Group on Business and Human Rights was pleased to contribute to the drafting of this statement, and it's relevant to our mandate in a couple of ways. As you may see in the statement itself, there is a recognition that the presence of armed non-state actors present unique challenges for business or economic actors that are operating in different kinds of zones, most notably conflict zones. The working group presented a report most recently to the General Assembly in October 2020, which focused on the specific issue of business, human rights, and the issue of conflict. In that report, we highlighted this unique dilemma. Business entities often have to engage with armed groups or armed non-state actors in the areas in which they're operating, be it a mine, an extractive area, to deliver goods via their supply chains. And this presents a dilemma for them as they try to respect human rights and need to engage with these groups. Similarly, some of these armed non-state actors themselves may be business entities, namely private security or military companies. They're both armed non-state, but they're also businesses. So there are unique challenges around this whole ecosystem. The recommendations in the statement, I think, are relevant in a couple of ways. One is that business entities themselves need proper guidance on how to engage with armed non-state groups, not only because of the potential legal risks and liabilities, but the ways in which they can engage to respect human rights themselves in terms of rights holders with whom they're interacting, but also how they can engage with armed non-state actors to ensure that those groups themselves respect human rights. This is a challenge, and it's an area that we have flagged where additional research is really needed in terms of what is expected, what is good practice, what role should business play. Similarly, what role should states play? And of course, the recommendations are in the state about states respecting their obligation to prevent human rights abuses and to investigate them and provide appropriate redress. As part of this larger state duty, we would say under the UN Guiding Principles on Business and Human Rights that states also have an obligation to guide businesses to really ensure that they, when engaging with armed non-state groups, are doing so in a rights-respecting way. The way we believe a lot of this can be achieved is through what we call heightened human rights due diligence. So businesses being aware of the context in which they're operating and not being blind to the fact that armed non-state groups are perpetrators of significant human rights abuses. So contracting with an armed non-state group that may have a business arm, buying or selling land, operating, paying taxes to an armed non-state group. I could go on about the number of dilemmas that may arise. So states need to provide guidance to companies and set expectations, and companies need themselves to educate themselves and engage with that heightened due diligence. And in particular, the recommendations to states, there needs to be effective access to remedy, which does mean thinking about the role of economic actors as well, to the extent that private companies may be connected to or causing an underlying human rights abuse because of their business activity in partnership or in conjunction with an armed non-state group, then that needs to be investigated and addressed as part of access to effective remedy. Now, one of the things, as I mentioned before, is of course, businesses often contract with armed non-state groups for security services and other things, and this is precisely where human rights violations may indeed occur. I would note that there are a variety of initiatives that we would commend that are very important to trying to help overcome some of these issues. One is the International Code of Conduct Association, which deals with the private military and security sector as a sector. And the second one is the Voluntary Principles for Security and Human Rights, which originally dealt with the extractive sector and the role of the extractive sector vis-a-vis security companies. So again, there are important initiatives, but really there still is a gray zone. I would commend our report to you because it does problematize the issue of business vis-a-vis armed non-state actors. And again, I want to congratulate everyone on the launch of this important statement. But as we see, much more work needs to be done to actually provide clarity around the issues identified. Thank you.
So without further ado, I suggest that we start the more work part of the discussion with the Q&A. Let's take about 25 minutes for the discussion, and then, as I mentioned, we'll wrap up, give each of our panelists a chance to wrap up. I'll take questions in a first come, first served basis, and I also suggest that we address each question one at a time. So we've already had people asking for the floor, and the first one is Anki, I always have to, Sjöberg from Fight for Humanity. Anki, you have the floor.
Thank you so much, Emily. So I'm co-director of Fight for Humanity. I just first want to congratulate everyone for this great event, and particularly for the great initiative, really, of all the special rapporteurs bringing forward this issue. So Fight for Humanity is working specifically on promoting human rights towards armed political actors and including non-state actors. So I wanted to have a question first to Agnes Kalamar. I think really extremely interesting. I was trying to take notes of everything, but there are so many elements, and I hear you're really kind of developing your thinking on this. So I just wanted to come back to one of the issues you mentioned on kind of the three factors that would determine the levels of responsibilities or obligations, indeed, by non-state actors. So you mentioned control in the classical sense, the level of governance functions and their capacities under international law. So I wanted to get back to the aspect on the control in the classical sense, because I know in the event we had together last year, also on human rights responsibilities, this question came up, and I know you had an interesting way also of problematizing this in terms of the classical sense of control, like more like IHL type, but also like what are the situations that we are facing now with kind of split control, maybe at certain hours control, and also I wanted to maybe link that to what does this mean for now with the virtual space, right, where we have rights as freedom of expression, and there are threats and so forth, where our actors are exercising control, also not in only the physical space, but also in the virtual space, and what we can do to affront that. And then just one point, so very interesting presentation also by Mr. Gehad Mahdi, I think on the rights Committee of the Rights of the Children. Just linked to that, I wanted to mention that we, as Fight for Humanity, will organize on the 18th of March with Independent Diplomat an event specifically on preventing the recruitment of children associated with our non-state actors. And we're going to be discussing specific, like, concrete efforts on how commitments have been implemented on the ground, with also the participation of the special representative. So 18th of March, the invitation will be sent out soon for those of you who are interested. Thank you so much.
Thank you, Anki. Special Rapporteur Calamar, do you want to answer directly?
Well, thank you very much for your kind words. I think you've already provided my answer in your question. I mean, what I have said in my report so far is that I think control, the notion of control, which is so essential to international humanitarian law, is indeed important, and I do not, I do not minimize it. What I call upon is for us to approach it in a more empirical basis. That is, first, to recognize that this can be elusive territorial control when looked into by experts who embedded themselves with armed groups. I've noted that territorial control varies a great deal. There are groups that have control overnight, other groups that have controlled over the day. Sometimes control is shared. And indeed, it is certainly the situation in many areas with the presence of cartel groups. So I don't have an answer to you in terms of how do we engage when an armed non-state actors have this kind of control, but I am calling upon us to ensure that these kind of scenarios are covered by whatever work we do. The second factor is that there are certain armed groups that have power over populations, but may not exercise control over territory as part of their strategy. Indeed, some armed groups do not want territorial control. And I want to point out here that the jurisprudence on crimes against humanity has clarified that the primary requirement for armed non-state actors is that they demonstrate a capacity to carry out an attack of the scale required by Article 7 of the Rome Statute. So that is derived from their functionality and the organizational requirement. Thirdly, I would like also to suggest that we need to develop a framework that is applicable to armed groups that operate extraterritorially. Here I have in mind groups such as Al-Qaeda or Daesh, which may have a territorial base, but that does not stop them from conducting operations in Europe or in other parts of the world. In my view, if we can hold them responsible for war crimes or crimes against humanity in the territory they control, in, let's say, Iraq or Syria, I do believe that if the scale of their operations abroad meet the seriousness requirement, we need to really consider what control will mean in those contexts. And then the fourth issue that you have also raised, which is very close to my heart, is that of the digital space. There is much control that can be exercised over population by groups that control the digital space, and it is incumbent upon us as we think through the protection of civilian populations and of victims that we integrate that kind of control in our understanding. So I do not have a definition of control, but I am very clear that however we're going to conceptualize it, it must be based on the reality we're trying to tackle. And we cannot just create another imagined control which bears no reality with the situation on the ground. Thank you.
Thank you so much, Rapporteur Calamar, for this comprehensive answer. Rapporteur Meltzer, I assume you want to complement something. You want to add something?
Yeah, thank you. And just briefly, I obviously agree with everything that was just said. I just wanted to point out that this whole question of control in the digital space is also an issue with regard to states, right? I mean, the whole interpretation, how do you interpret jurisdiction for the purposes of human rights law in the cyberspace? And that has a real effect on rights just as privacy, but it goes beyond that. Even in the realm of my mandate of torture and ill treatment, we know that in an appropriately narrow situation, threats can cause severe mental pain and suffering. So we know that intelligence services and some governments actually use cyber means to persecute people, to threaten them, to break actually their will, without ever exercising physical control over them, or even over people that are not in their territorial control. So I think that's really, it's not just an issue with drones, but really also in cyberspace, and that obviously also then applies to non-state actors. But so, you know, surveillance and all of these can be so intrusive today that they can actually cause and inflict severe pain and suffering and push, especially fragile people that are otherwise also under threat, can push them to suicide. I mean, we've seen it, cyber mobbing and so on. So I think it's a very interesting area where obviously the influence of non-state actors exponentially grows. Thank you.
Thank you. So now I'll give the floor to the next speaker for his or her question. Sartak Ward. And again, apologies for any mispronunciation.
No, it's absolutely fine. Thank you to all the experts and special rapporteurs for the wonderful interventions. I noticed that Special Rapporteur Nils Melzer had mentioned.
Can I just ask you to just introduce, say which institution you belong to, whether you're a student?
Okay, I'm Sarthak Roy and I'm studying LLM in International Law from the Graduate Institute of Geneva, and I've followed this work for a long time now at the Geneva Academy. So Professor Nils Melzer had mentioned that there is a lack of international framework despite the existence of robust laws. So I was wondering how much could it be attributed to the fact that non-state actors have never been active stakeholders in the treaty making or norm creating process? And if so, in the future going forward, would we witness a change in this process, or would states be still concerned about providing legitimacy to these non-state actors? Thank you.
Thank you, Sartak. Special Rapporteur Melzer, or do you want to answer directly?
Yes, obviously. Do you want a short answer or a long one? No, this is obviously, it's a very relevant question. I mean, what I do whenever I speak to students, I encourage them to do PhDs or research on that topic, on how do we, you know, make that step into the reality of the 21st century, where we still have a governance system that on paper very much reflects the Westphalian state-based system, but in practice, much of the world is really governed by corporations, and even governments are very strongly influenced by corporate actors, and not only corporate actors, obviously, then we also have the political armed non-state actors and so on. So honestly, this is a huge issue of global governance reform. I don't know whether you know, it is desirable to go away from the state-based system, because it opens up a Pandora's box. But what we certainly need, we need in the institutional framework and the procedural framework to rein in those actors that are so influential. Because human rights law has been created to rein in the power of the actual power holders, the states, at the time. So now we have others that, alongside states, exercise an enormous influence on private sphere and integrity and private rights, human rights. And so we need to find ways, not just in the normative framework, you know, recognize that they're obliged to respect human rights law, but not provide the institutions and the procedures to actually enforce it. That obviously will not be sufficient. I don't think I can develop this further at this point, because it's a very complex and very challenging issue, but you're spot on. I think that's the main challenge of the coming years.
Thank you so much. Does any of the speakers want to compliment? Yelena, go ahead.
Yes, thank you, Emily. Just quickly on the issue of the corporate contribution to the international legal framework, they of course did not create legal framework, they do not draft the conventions and treaties, do not sign them, but they do contribute, and actually they very much influence. In our last report on migrant detention and border management, we actually noted that private military and security companies have a very strong influence, either through the contribution, through their expertise, or through their lobbying, or a certain type of propaganda, but they contribute to the norm-making on the international level. So it's slightly different for corporations, and specifically for this sector of the private military and security company, when they use the security as a strong argument to contribute and to expand their markets for operations. Thank you.
Thank you, Yelena. Okay, now the third question, I'd like to give the floor to Mr. Vugar Hajiev, who is a counselor of the mission of Azerbaijan here in Geneva.
Thank you, Madam Chair. The issue under discussion is an interesting one, and in all circumstances, it seeks to ensure the protection of human rights and to prosecute and punish perpetrators. However, as we all know, the armed non-state actors, by its definition, violates legislation of relevant country. Therefore, they are illegal armed groups, and majority of them are terrorist groups and violate human rights. They use violent methods in order to achieve their goals. Under international humanitarian law, acts of threats of violence, the primary purpose of which is to spread terror among the civilian population, can be considered as falling into the category of act of terrorism, and majority of these armed non-state actors have recourse to these methods. We are concerned that the acceptance of terrorist groups as a party is in their interest, and in this way, the armed non-state actors will strive to get publicity. At present time, the statement of the armed non-state actors, if submitted by member state, is disseminated within United Nations. Indirectly, it encourages illegal armed groups and states that support terrorism and legalizes their activities. Thank you.
Thank you. I'm not sure that there was a question there. And may I also point you to, I think, the last paragraph of the joint statement that specifies that nothing in the statement shall be construed as affecting the legal status of armed non-state actors. So definitely the initiative aims at giving victims more rights, but is not legitimizing any acts in violation of international law, but maybe either Special Rapporteur Melzer Calamar, Mrs. Apparat, or Mr. Mali want to add something. No?
Well, all I will ask is that a government's naming of a group or individual as a terrorist bear no implication on international law. So Azerbaijan can name whoever they want a terrorist, as far as I am concerned, unless the Security Council has determined so. It bears no implications on the way I will approach their obligations or their responsibilities. And even, I will add personally, I have over the last 5 years worked extensively on groups that are considered as terrorists, including by Security Council resolution. I have also, unfortunately, worked on an enormous amount of people who have been deemed terrorists, who are journalists, who are human rights defenders, who are dissident. Therefore, my approach to the issue is that as a concept and as a term, it has been open to an incredible amount of abuse by state, and it is one that I cannot take as a basis for for proper protection and work. And I want to refer you to the work of my colleague, the Special Rapporteur on Human Rights in Counterterrorism.
Thank you for. Ooh, Sorry, thank you for this precision, Special Rapporteur Kalamar. The next speaker is Mr. Mohammed Janabi. You have the floor.
Hello, thank you very much. Thanks for this interesting event. Actually, I had a question, maybe it's very relevant to the previous question. When we say that there are human rights obligations of non-state actors, the next question will be, what is the source of these obligations? It's quite important to understand the source. It's not enough to say, well, you are obliged to respect human rights. We need to know the source. I know many instruments mentioned during the event referring to resolutions, guidelines, recommendations, and we know all of these are soft law, and we understand the problem of the soft law. It's itself a problem in the context of states. So what about if we put it in the context of non-state actors? So I mean, it seems all about what we need the law to do in the future rather than the practical solutions to the problem of non-state actors. Yes, this is my question. Thank you very much.
Thank you. Does one of you want to address it first?
Well, I mean, I can refer you to my report. I have spent quite a lot of time trying to explain where the legal personality of armed groups can come from and what are the various sources for their obligations. In terms of their legal personality, the sources may be traced, among others, to some of the treaties and customary law. There is, under the de facto authority legal construct, armed non-state actors inherit the treaty obligations of the state. They have displaced, under the customary law approach, armed non-state actors are bound by customary law, including customary human rights law. So I think the sources can be identified. Their obligations may be linked to the inalienability of human rights and those actors' capacity to exercise human rights obligations. My own position is very much similar to that of Andrew Clapham, who has ultimately gotten a bit tired of working for 10, 15 years, arguing endlessly over the legal personality of armed groups. There are so many different understanding of where legal personality comes from, and I think I will agree with him. We should stop treating it. We should realize that it is an overstated, highly subjective notion that is linked to and formed by individual scholars' conception of the whole system of international law. This is reflecting an outdated vision and, frankly, a complete lack of imagination. That's my position. Thank you.
Thank you. It's a very clear position. Special Rapporteur Melzer, you want to add something?
Yeah, thank you. I don't know if I have the imagination to solve it, but I think it is good to connect it to the doctrine of what are the sources of international law. We can say, well, there's three sources we know from the ICC statutes, the treaty, the custom, and general principles. And we all know that most of treaty human rights law does not directly bind non-state actors, but we can identify some norms, as what was mentioned by Gerrit Madi, the norm in the optional protocol to the Convention Against the Rights of the Child, where armed groups are directly addressed by a human rights treaty and prohibiting them from recruiting children. And we know it from humanitarian law, where many of the direct obligations that non-state groups have are basically equivalent to human rights norms, the prohibition on torture, certainly, and many others. And so I think substantively, there really isn't much doubt that there is this expectation of and more than just a moral expectation of the international community that non-state actors that have this kind of control over the rights of individuals respect those same rules. Most of them are not treaty-based, but they would be, then you can say it's either custom or general principles of law. Let's not underestimate that we have those elementary considerations of humanity. We have, certain basic protections there that can be derived directly from the general principles of law, of elementary considerations of humanity, and therefore, and then you can derive an international obligation from that. But again, I think we also have to be honest enough to say, technically, what does that mean if a court were to give a right, a duty to pay compensation? Who has to pay? If it's not a corporation, where it's fairly easy, but and then I think we also have to be honest enough to say, well, maybe we have not been imaginative enough yet to actually create a concept and get it accepted in doctrine. I mean, it's not impossible. All we have to do is we have to do it, right? Law is a human concept. It's a human product that we have come up with. And yes, it's right, we need a bit of imagination, but I think it's feasible and it's absolutely necessary. So that's also why we encourage all stakeholders to actually engage in this process and clarify these issues that you're absolutely right to raise. Thank you.
Thank you so much. And if I may, addressing the Geneva Academy actually has a research project that addresses the issue from the other end or in another way. And it's a project about how armed non-state actors actually do react to norms and how they think they are bound and which kind of norms they want to apply. This project is called From Words to Deeds. It also has case studies. I invite you to check it out on the website. And two of the researchers involved in the project also have published an article on how you can think of armed non-state actors being bound by IHL and IHRL. And I just posted the link on the chat feature, so I invite you to check it out. I think we have time for one or two more questions, and my apologies to people who have asked for the floor and won't be able to have their question answered. So now I would like to give the floor to Catherine Fortin for her question.
Thank you, Emily, and thank you to everybody that took part in the session today, and also for the special rapporteurs who've led this initiative to bring forward this statement. My question, having worked on this issue a lot myself as well, and I feel like I should also put my book in the chat, because obviously I also wrote a book on trying to answer this difficult question of how and when armed groups are bound by human rights law. The question I want to ask relates to this issue of legitimacy, which I know is continually the issue that's thrown back to you when you talk about armed groups and human rights obligations. And we all know the legal answer, which Agnes Calamar indicated immediately, which is the fact that an entity is bound by international law in no means that that entity is a state or even approaching statehood. And as Emily mentioned, we have that important clause in the statement from the UN experts reiterating that under domestic law and international law, this doesn't change anything. But we also know that international law and politics are very close here and sometimes get a little muddled, and that in fact on the ground it can be a very big problem, and particularly in the mind of states. So I'm curious to hear from the special rapporteurs here today about their experience of this dynamic on the ground and how perhaps they've dealt with it. Maybe if they could share insights on that, how much of a problem is it, whether there are any specific measures they can take to lessen it as a problem, and whether in a general sense there are measures that can be taken to also put a brake on this legitimacy argument within the human rights discourse in a general sense. So that's my question. I'm curious to hear your ideas.
Thank you so much, Catherine. Who wants to go first? Okay, let's go ahead.
Well, thank you. Obviously, it's in practice, it is a real challenge. I mean, I can just speak from the context I've experienced, and I think the Eastern Ukraine is an interesting context because it's a very recent context where we have, very kind of fairly sophisticated groups governing a territory, running prisons. Many of them are dissidents from the former government forces and intelligence services and so on. So they basically mirrored the whole state structure on the other side. I mean, to the extent that they can, but with courts and everything. I mean, it's not just an armed group somewhere in the jungle, but it's really a fairly sophisticated system. And so there, clearly in engaging with them, it's a very delicate issue. And the fact that I included this in my report and some direct recommendations to those de facto authorities was not taken very positively by the government of Ukraine. I was severely attacked in the council when I reported on this. But I felt it was this just reflected the reality. We had more than 10,000 detainees in the power of these groups, and there was no point in ignoring that they are de facto the authority. And so we had to address them like this. As I mentioned before, it was a great advantage not to be a treaty body, because I could simply sit in those, command offices and of those groups and basically say, look, I'm not coming here as a treaty body. I have nothing to do with your status. It's really about the human rights of people in this territory. And I have to admit that obviously also rhetorically, it is much easier to say, well, if you think you want to achieve legitimacy as state actors or something in this direction, well, then first you probably should behave like one. And then you have the Geneva Conventions that actually have to give access to the ICRC to prisoners of war and so on. But as long, obviously, as you don't even do that, I don't think there's any point for you to even start speaking about this. But it's a very delicate issue in practice, because every word you say will obviously be pulled out of context and quoted by either side. And so, yeah, it's a tightrope act. But I think, again, and I say for the third time, just because I think it's very important in practice, that we do have the independent special procedures mandate holders that don't operate as treaty bodies. That is one of the great added values that we have in actual underground practice. I think that we can do that while avoiding this whole issue of state parties or not parties, statehood or not statehood.
Thank you, Niels. Yelena, do you want to add something?
Yes, thank you, Emily. I think this is a very interesting question. And in terms of our mandate on the PMC's part, one of our latest reports that we presented in 2020 to the General Assembly on the involving trends of mercenaries, it's a very tiny paragraph, but it's something that we are really keen to look more into in terms of the legitimacy, is the non-state armed groups, such as rebel groups, towards the end of hostilities or even during, but if they are losing some kind of control or their legitimacy within the country, they're transforming into the PMCs. And we have one paragraph that, and through this transformation going from non-state armed groups into legitimate private military and security companies that can even be registered in the market, I think this is a very new phenomenon that we are seeing from the working group and mercenary perspective, and we are trying to examine that more. And we've seen that with the Syria, with the Syrian fighters were leaving the non-state armed groups, the rebel groups from northern part of Syria, and being recruited in Libya and Nagorno-Karabakh and to some other places around Africa now. So it's something that is new for us. And if somebody is working on it and wish to send us any research on that, we'll be happy to take it. Thank you.
Thank you, Yelena. I think for the interest of time, we'll cut the Q&A here. My sincere apologies to Mariam Abel, Eli Mukuna, Isota Desanoda, and Nika Farnworth, who had asked for the floor and won't be able to ask their questions. I suggest to ask each of our speakers to maybe say a few sentences of conclusion, highlighting possible new measures, discussions, and the way forward. I want to start with Special Rapporteur Kalama. You're on mute. Agnès, you're on mute.
I'm going to suggest that we start with the last Special Rapporteur who spoke.
Okay, perfect. Mr. Mahdi?
Yes, thank you, Elena. I think the most important thing now to hold the non-state armed groups accountable to their activities is for the UN Security Council to be more active in this respect. And they have already decided to establish some special courts in this respect in some countries. Moreover, it is important also for the UN to facilitate somewhat peace process between governments and non-armed groups. It happens in Colombia, in Sri Lanka, recently in South Sudan, and the ongoing process as we are watching in Libya as well. So this is, there is a cooperation must take place between all countries in order, as I said before, to criminalize in the domestic laws the unhuman activities of non-state armed groups in order to prevent impunity and to tighten the gap on non-state armed groups. Thank you.
Thank you so much, Mr. Madi. Yelena?
Yes. Well, thank you again, everybody, and thank you, Geneva Academy, and thank you, Emily. I would just like to stress that only clear legal norms backed by state enforcement can ensure accountability and provide effective remedies for victims. Particular attention must be paid to companies whose activities take place in an environment with an increased risk of serious human rights violations and abuses. States should also use all tools at their disposal to enforce human rights standards, including through licensing or authorization regimes and contracts. And just to finish on that, the working group thus supports the incorporation of these norms into an international legally binding instrument on PMCs, rather than relying exclusively on self-regulation and voluntary non-binding initiatives to complement national regulations. Thank you.
Thank you. Special Rapporteur Meltzer?
Yes, thank you very much. Obviously, much could be said, but much has already been said. I would just like also to second what Yelena just said about the private military and security industry, because I used to serve actually in the steering committee of the original steering committee creating the association for the code of conduct. So I was a civil society member, and so I think that's very positive to have these types of initiatives, or also, let's say, the declarations that are being supported by the Geneva Call, for example, for those armed actors. But in the end, they don't replace a formal, legally binding framework. And again, not only a normative one, but it requires an institutional one. And as it also is, even for states, we have the norms, we have the institutions, but sometimes nothing happens unless we have the political will to also enforce this. And to make this a priority, it will be painful. It costs not only money, it also requires us to face reality as it is. And you know, sometimes behind many of those armed groups are supportive states that obviously serve their own interests by working through and with these groups, or allowing them to work, and the proxy wars and a lot of this. I think all of these issues need to be addressed if you really want to address the damage done by non-state actors, because states, it's not like states have nothing to do with it. And so I think we need all of those elements: the normative framework, the institutional one, the enforcement procedural possibilities, and the will to do it. But we also need to put the spotlight also at the same time at the states, and what do states have to do with it, with that prevalence of non-state actor violence and the space that is given to that, and you know, that allows them to actually cause so much harm. Thank you very much.
Thank you very much. And last but certainly not least, Special Rapporteur Kalama.
Okay, 2 points. First, I want to reiterate that there is no evidence that the recognition of armed non-state actors as subject of international law or the adoption of Security Council resolution regarding those groups have resulted in their legitimation. When armed non-state actors have become legitimate, it is not because of international legal principle or lack of, but for eminently political reason and or as part of a peace-building process. So the fear that have been expressed before are not grounded in empirical evidence. Second, I believe that the current state of the world demands that we be prepared to question and evolve the legal and theoretical underpinning upon which we are basing our work to ensure that those underpinnings are fit for the world we live in, for the challenge we confront. We confront climate change, pandemic, armament race, technological industrial revolution, artificial intelligence, and we are also confronting and extremely influential armed groups and non-state actors. Let me recall that some corporations are more powerful in financial or political terms than some states, that corporations are currently those in charge of our life online. And that life online is becoming indeed a primary life for all of us, is also becoming a factor of instability and conflict. If we do not have the legal framework applicable to the challenges, we need to develop those this legal framework. The world we live in may well be the equivalent of an earthquake force 10 on Richter scale. This is equivalent of human revolution in human history terms. Law must follow those challenges, and indeed, we would have liked them to help them address those challenges. I was at a meeting yesterday when someone told me, international law is not meant to save us. I may agree with that, but it's also not meant to kill us, or it's not meant not to protect us. And when international law is unable to protect the victims, is unable to even account for the victims, is unable to name what happened to the victims and to look for remedies to the victim, it is up to all of us to challenge the law and to build a legal framework that will place the victims at the heart of them. That's a challenge we are confronting with armed groups, and I hope this meeting will have contributed for all of us to take on that challenge and to protect all of the people, the millions of people around the world who are being victimized by armed groups and who have no recourse at the moment, and whose violations is not even named as a violation of human rights. Thank you very much.
Thank you so much, Special Rapporteur Kallenbach, for this vibrant call to action and to legal activism in a way. I don't think we could have ended the discussion on a more powerful and insightful and inspiring note. So without further ado, thank you everybody for attending this event. I think the number of participants, which range between 120 and 180, shows how topical the topic is. Thank you to all our speakers, and have a good day, afternoon, night, or morning, depending on where you are. Goodbye.